Hello, I am Craig Tingle of the Tingle Law Firm, and I want to thank you for tuning in and taking a few moments to learn about the rights and duties of landlords in Florida. If you rent a house, apartment, condominium, or mobile home to another person, you enter into a legal contract known as a rental agreement. This rental agreement need not be in writing. If the rental agreement is in writing, it is a lease. This agreement has certain basic conditions specified by law, and you should understand them before you enter into the agreement. As a landlord, you have certain rights and you also have certain duties. Even in the absence of a written lease, the law imposes duties and gives rights to the parties. If you require the prospective tenant to complete a rental application and the applicant is a member of the United States Armed Forces on active duty or state active duty or a member of the Florida National Guard or the United States Reserve Forces, you must notify the applicant of the application's approval or denial within 7 days of when the application is submitted. Your obvious right as a landlord is to receive rent for the use of the property. Another important right is to have your property returned to you undamaged at the end of the agreement. It should be returned in the same condition in which it was received, except for ordinary wear and tear. In return for these rights, it is your duty to provide a home that is safe and meets housing code requirements and to make reasonable repairs when necessary. The obligations can be limited sometimes under the lease. It is also your duty to respect the tenant's rights. One of the most important of these is the right to peaceful possession. By renting to the tenant, you give that tenant possession and use of your property free from interference. This means that you may not enter the home frequently at odd hours or without notice. Rights relating to reasonable inspection are often set forth in the written rental agreement as well as in Florida law. You have a right to protect your property through inspection, but you must give a reasonable notice of at least 12 hours. You do not have the right to show the property to possible buyers without notice to and agreement from the tenants. It is unlawful to increase a tenant's rent or decrease services to a tenant in retaliation against a tenant. Retaliation may be presumed if it occurs after a tenant has complained about housing conditions. It is also unlawful to lock the tenant out, intercept or shut off utilities, including water or electric services to the tenant, or to remove doors, appliances, or tenant's property from the home. A landlord who does this can be ordered to pay a tenant damages in the amount of 3 months' rent or actual damages, whichever is greater. To end the tenancy, if the unit has no written rental agreement or if the lease does not state otherwise and the unit is written on a month-to-month basis, you must give at least 15 days notice in writing before the end of any monthly period. A week-to-week rental period requires 7 days notice before the end of any weekly period. Such notice must be in writing and should be delivered personally to the tenant, but it may be posted at the door if the tenant is absent from the premises. If the written rental agreement requires a tenant to give notice of up to 60 days before leaving the unit, the landlord is also required to give the tenant the same notice period if there is no intention to renew the lease. If the rented property is foreclosed upon, the purchaser at foreclosure sale may terminate the rental agreement for existing tenants only by delivering a written 30 days notice of termination to the tenants, if the purchaser intends to use the property as a principal residence. The tenants are obligated to pay rent during the 30-day period for any amount then accruing. The purchaser does not assume the duties of the landlord unless the purchaser assumes the existing rental agreement or enters into a separate rental agreement with the existing tenants. This 30-day notice does not apply to all tenants. You should consult with an attorney to determine if the 30-day notice is applicable. You should also consult with an attorney because federal law may take preemption over Florida law on this subject. Additionally, both the landlord and the tenant have the duty to observe state and local laws concerning the use and condition of the property. The basic rights and duties mentioned here apply whether or not the agreement between the landlord and the tenant is in writing. A written agreement is best because it serves as a memorandum of other terms and conditions. A written agreement is best because it serves as a memorandum of other terms and conditions, such as use restrictions on the number of adults or children or types of pets to be allowed. And if you wish to provide for lease terms of 1 year or more, the agreement must be in writing to be enforceable. If the tenant moves out before the end of the rental term and leaves the property vacant, This usually is considered to be an abandonment of the tenant's rights. The law presumes an abandonment if the tenant is absent for at least 15 days without previously notifying the landlord of an intent to be absent. After abandonment, you may re-enter the dwelling unit. The rights and remedies often are complex, and you should consider legal advice or assistance. The situation is more complicated if the tenant seems to have gone away but has left all personal property on the premises, or if there is a considerable amount of unpaid rent. In such a case, you should consult an attorney before trying to dispose of the tenant's possessions or re-renting the property. Another complication occurs when a tenant fails to pay the rent or refuses to move out at the end of the rental term. Under these circumstances, you may evict the tenant, but only if you have taken the proper legal steps to commence an action for possession according to a very specific timetable. You must serve proper notice or notices on the tenant to terminate this rental agreement. If the tenant ignores these notices, you are required to file a complaint in court and have the tenant properly served with a summons and complaint. 5 business days after the complaint is served, you may request the court to set a date for a hearing. However, if the tenant fails to answer the complaint within the 5 business days or fails to pay the rent that is due, then you can proceed to eviction without having a hearing first, though you must get a court order before actually evicting the tenant. If the tenant disputes the amount of rent that is due, the rent does have to be deposited at the court and a hearing must be held. If you wish to collect money damages from the tenant, you must wait 20 days to set a hearing on damages. At the hearing, you can ask that the tenant be evicted. If the judge agrees that the tenant has violated the terms of the agreement, a sheriff's deputy will serve an eviction notice on the tenant. The tenant then has 24 hours to vacate your property, or the sheriff can return to remove the tenant and supervise the removal of the tenant's belongings. Because these proceedings are so technical, it is wise to have them handled by an attorney. Because a landlord-tenant relationship is a legal contract, you should understand its various provisions before you rent your property to another. Remember that as a landlord, you will be required to provide living quarters that are safe and keep them in good repair. Your obligation for repairs can sometimes be limited under the lease. You will have to turn over possession of the property to the tenant, free from unnecessary interference from you. In return, you may collect rent and on reasonable notice or in cases of emergency may inspect the property. At the end of the rental term, the property must be returned to you with no damage beyond ordinary wear and tear. The landlord has certain duties to account for or refund tenant deposits upon termination of the tenancy. Many of these basic conditions apply whether or not there is a written agreement. If you believe you need further legal advice, please feel free to contact me at Tingle & Associates PA at embarkmail.com or by calling 850-650-8138 or visit our website at www.tinglelawfirmdestin.com. I look forward to meeting you.